We will go on the record.
We'll go on the record
23
in the matters
CF
172,
24 CF 24 CF 208 versus Joseph
The
Berg.
state appears through
District
Attorney
Attorney
Kevin
District
Schmidt
Attorney
in
Kevin
person.
Schmidt in
We have
person.
Mr. Berg
We have
appearing
Mr.
in
Berg
person
appearing
with
in
counsel
person with
Daniel
counsel
Chapman.
Daniel
We're
Chapman.
set today in this
We're set
matter
today in
for
this
the
matter
sentencing
for the
portion of the
sentencing
case.
portion of the
Mr.
case.
Berg pled
Mr. Berg
guilty
pled
to
guilty
one count of
to
possession
one
of a
count of
firearm
possession of
by
a firearm
convicted
by
felon,
convicted felon,
and one count of
one
felony
count
bail
of
jump.
felony bail jump.
The court ordered a
The
pre-sentence
court ordered a
investigation
pre-sentence
report. The
investigation
court has
report.
reviewed
The court
the
has
document.
reviewed the document.
Mr. Schmidt,
Mr.
any
Schmidt,
material facts
any
or
material
corrections
facts
for the
or
record?
corrections for the
I
record?
don't have any. I don't have
Mr.
any.
Chapman, Mr.
None that I
Chapman.
noticed. None that I
And did
noticed.
you go over the
And did you
PSI
go
with
over the
Mr.
PSI
Berg?
with
Yes, I
Mr.
did.
Berg?
Yes,
Mr.
I
Berg,
did.
Mr. Berg,
You notice any,
you notice
anything that would need to be
anything that would
corrected
need to
on
be
the record?
corrected on the
No, Your
record?
Honor.
Okay,
No, Your Honor.
thank you.
Okay, thank you.
We're in victims' rights
We're in
compliance,
victims'
but
rights
victims are
compliance,
not
but
making any
victims are not
statements,
making
correct,
any
Mr.
statements,
Schmidt?
correct, Mr. Schmidt?
I don't believe so. I
All
don't
right,
believe so.
Then,
All right,
Mr.
then,
Mr. Schmidt, argument and sentencing recommendation.
The state's going to be asking the call the Department of Corrections recommendation. This is a case where Defendant Joseph Berg's died in an accident. 3 months later, Joseph Berg found himself in possession of ammunition, and extremely under the influence of something. As that case has gone on, a new case in Polk County, which subsequently resolved. That's what triggered the bail jumping that piggybacked off the second case here today. During the duration of the Polk and Burnett matters, Mr. Berg has been in jail for an extremely long period of time. Taking a holistic approach, looking at all these matters together, Mr. Berg's history and his personal circumstances in his life, the state has come to the conclusion that 14 or so months of jail, initial punishment during that period of time is sufficient. And the court should look to place Mr. Berg on probation for a period of 4 years on the 23 count and 3 years on the 24 count. Between the two of those cases, great deal of time hanging over his head, minus the 14 months he's already served. Analyzing this from the Galleon perspective, I think that's what the court should do. So before getting into the gravity of what the offense is, I want to emphasize something that maybe is a bit back and forth in the Department of Correction recitation of the facts, and that is the depiction of Mr. Berg's behavior in the 23 case. It's one of those things where when you read it on paper, probably sounds a lot worse when you watch the body cam footage. His behavior was entirely on body cam. It's not really subject to speculation what happened. In that video, Mr. Berg is just, I would describe completely out of it when the police interact with him. And by that I mean unresponsive. He's kind of just standing stiff as a board. Police move in and about and around him. He doesn't. At one point, they use a beanbag gun because they're concerned because of the gun and the gun and the rifle and the ammunition. They shoot him 3 times. With the beanbag gun. Doesn't budge a centimeter. That's a weapon that has a great deal of force. Great deal amount of pain. See the injuries afterwards. No response. So at the time, whatever he was under the influence of.
Is that what they meant by less lethal shot?
Yes.
That was
Cop speak.
confusing.
They mean it's like a shotgun. That fires beanbags.
I only know it as a beanbag.
So that's what they're talking about. It hurts a lot. I don't think I can say more than that. And seeing no reaction from him, shine a light in his face, no pupil reaction. That's what the passive resistance was. At the hospital is when Mr. Berg, whatever he was under started to wear off. He starts becoming speaking. He starts asking questions. He's very clearly with the tenor of what he's saying and confused where he is, what's going on. It's at that point that kicks trooper. Double check which trooper it was.
Anthony Olson, I think.
Yes, that's the point when he kicks Trooper Olson. It was coming out of this drug-induced in this situation. The reason I wanted to emphasize that is the term resisting or obstructing can have a lot of different meanings. It can someone, I'm being arrested, I'm going to hit you back and punch you in the face. So I think the court hears sometimes of pulling away, and then it can encompass situations like this where a person is just incapable of really responding. Something they're under the influence of. In Wisconsin, when you're talking about voluntary intoxication, that can't even be talked as like criminal liability. It's absolutely something that should be considered at sentence. In terms of figuring out what exactly obstructive or resistive behavior was. I know when I read the PSI's recitation, and even the way it comes off, police reports, criminal complaint, it might come off as something else I wanted to be clear about. So the court understands why the state, and why the DOC came to the conclusion of probation, given what was written before. So I think that also sheds a major light on what probably is the worst part of this incident. What is the nexus or the cause of it, which is a form of substance abuse. The PSI details a history of substance abuse, and it's actually pretty lengthy. It also documents multiple times in which the defendant actually did treatment and completed treatment paradigms. It's been a while since done one last. Get a significant long period of sobriety that occurred up until his daughter passed away, which was a couple months before the initial incident. So I think when I read the PSI, I think DOC is rightly and correctly identifying that this one event Mr. Berg's life, his daughter, was a really transformative one to the negative. It really affected him. I think it would be improper to assume it's a coincidence that 23 CF-172 happened so soon after that. If you accept that, which I think the court should, a person with substance abuse relapsing hard after their toddler age child passes away, affects the McCleary-Gallion analysis quite a bit. It tips the analysis heavily into the rehabilitative potential category. We know he has a substance abuse issue. We know long successfully completed treatment. We know he's achieved long-term sobriety in the past. Therefore, we have good reason to believe that in conjunction grief counseling, substance abuse refresher might change Mr. Berg's behavior to get it back before 23 CF-172. The nature of that trauma, it being long-term that lasts. The best way to protect the public would be a long-term plan that contemplates the substance abuse, mental health, the grief, as opposed to maybe a medium or short jail sentence or a prison sentence. Those would be a short-term solution to a long-term problem. So the best way to achieve purposes is to plan a long-term solution, longer form of probation. I think that the gravity of the offense, it is large. It's still use of controlled substances. It's still in the presence of a firearm. It's still involved in an officer being hurt. That's why he pled to the offenses. There will be so much hanging over his head while he's on probation. I think with the amount of probation was hanging over his head, enormous amount of pre-sentence credit. I think the seriousness of the offense is not depreciated. And I think in total, what this would be if the court followed the DOC's recommendation, followed the state's recommendation, this would be the best way to achieve all the purposes of McCleary-Gallion. The best odds of protecting the community by rehabilitating Mr. Berg and not depreciating the seriousness. 14 months jail is what did that. The longer term of probation is what's doing that. Big sword in terms of the withheld sentence do that. Thank you.
What is the jail credit?
I counted 431 days. I have the dates if anyone wants them.
All right, thank you. All right, Mr. Chapman.
Your Honor, I'm not sure if you're actually aware of the circumstances as to how Mr. Berg's daughter died, but it was actually an in-home accident.
Very aware, and
I won't go into detail. Then.
it's more than just a passing of a child.
It's more than just having a daughter die. It is extremely traumatic. The incident.
Yes, Judge. And then I will not belabor the point. I just wanted to make sure the court was aware of that if you were not. And I agree. Based on the PSI, based on Mr. Berg and his mother's statements, I think that's all. If not excusable, definitely understandable. That a person, despite being sober for 4 years, relapse under circumstances like that, and he did just go off the deep end. In addition to the state's the body camera video, I would also point out, I really don't think depiction of events based on victim one's recitation of things is entirely reliable. I think it is incredibly likely that Mr. Berg was invited over to the cabin that night. These two have a pre-existing relationship. Two of his children. I don't believe that a person would just be driving past the motorcycle to scare her and decide to sit at a bonfire calmly. I think the two were using drugs together. She admitted to that. He forced the drugs down her throat. And her explanation never encompassed how he was in the cabin. Stuff was apparently found in there. I just don't think she's a reliable witness. That doesn't really change anything regarding the underlying facts, but it does change the tone of circumstances that night. Mr. Berg was on the video approximately 6 or 8 feet away from where the gun was. His DNA was found on the magazine, although not on the other parts of the gun, and there was no indication that it was actually fired. He didn't reach for it. He didn't threaten the police were there, although obviously he was barely coherent at the time the police were there. I think the most important factor in PSI's recommendation is simply the fact that since he's been sentenced in Polk County, he's been on probation and he's been fully compliant since July 10th. He's been out of custody. He's been on probation. He's been doing everything. Then no violations. He's been attending Alcoholics Anonymous classes. He's been sober. I think the fact that he is showing right now that he's in the community staying sober is the best argument that can be made that path should be continued in the near future. Definitely a lot hanging over his head. If he messes up, he's facing a lot of time. But I think that is probably the primary consideration as to why probation is appropriate. He is showing that he's an appropriate candidate for probation. Also, he's spent 431 days in custody, and given a confinement sentence, a large portion of that would be eaten up right up front. If the court imposes additional jail time, that would not necessarily involve the credit. And if the court wants to impose a prison sentence, I believe that could also be appropriate in this case. He does have a long history of drug use, using methamphetamine 15 years old. He's been sober since his release from prison after his 2019 earned release program. And he stayed sober from there until he relapsed in June of 2024. He's been employed full time since getting out of jail. Not his normal line of work. It's a mark of his character that he's working any job necessary in order to provide for his family. He's employed full time at Chipotle. He's been compliant with probation. He's been mending with his wife and children. I agree with both the state and the PSI recommendation. The proper thing to do to protect the public, place him on probation for a long period of time. 4 years is appropriate. Whether it's an imposed state prison or withheld sentence, either way, we all know significant prison sentence if he does not follow through with what he appears to be doing now. And if he stays sober, I believe the public will be protected.
Mr. Berg, do you care to make any statement?
It's your only opportunity to let me know anything you want, or to correct anything that may have been said not as accurately.
I guess I'd just like to apologize for my behavior at the time. My daughter passing is not really just kind of happened that way, I guess. I'm sorry. That's it.
Thank you, Mr. Berg. You were just in Polk County not too long ago when you got sentenced and been sentenced to the force. Have an understanding of what the court must look at when they sentence an individual. First and foremost is the nature and the gravity. How serious is this? Second, I have to look at your criminal history, your education, those types of things. And then third, I have to look at protecting the public. This is very serious. As Mr. Schmidt stated on black and how it first comes to this court and how it is unless I have motion hearings to be able to hear specific facts of a case through arguments at sentencing. All I get is the black. And in the black and white, it looks extremely scary. And it looks extremely serious. Mr. Schmidt did correct that and say upon the body camera footage that it's scary than what I read in the black and white. Because you can't make that up. Body camera and it shows what happened. And Mr. Schmidt said that for the most part, your behavior was caught on the body camera. But again, if it's less serious the black and white, it's still serious. You were as Mr. Schmidt or as the PSI said, you were kind of in a catatonic state. You weren't responding to anything. Pupils were not making any reaction. You were shot with the less beanbag shotgun 3 times. And it pretty much didn't do anything to you. You didn't even flinch. So that shows that you were in this state where you truly had no idea what you were doing. But again, as you said, there's no excuse for your behavior. You put yourself in that position. You put on your shoes. You put on your pants. You did those things. And you were in that area. I have to look at your criminal history. You do have. I wouldn't say an extensive criminal history, but you do have a long criminal history with serious convictions. The Polk County matter. I'm going to tell you that was scary too. Hearing the incident that occurred in Polk shortly after release from this county. But you were still in that grief. You're never going to get over the passing of your daughter. I lost a daughter. I know the feeling. I didn't lose a daughter in as traumatic of a way. I am so sorry for your wife's loss, for your family's loss.
Thank you.
No one can even have the words to make. You will never ever get over it. It just gets easier. It's been 12 years for me. And I understand that. So I guess I'm going to say, I kind of understand where you just lost it. I don't understand to that extent. Not been addicted to substances. But I do understand the desperation and the inability to be able to want to control yourself and your behavior. But again, you're the one who's responsible for your behavior and what happens and transpires. And that's why we have you here today for sentencing. I do commend you for working at Chipotle. Hopefully you get a free meal. You get to work at Subway. You get a free meal. You get the best part of the job. But you're doing what you need to support your family, to remain sober, and that's the number one. How many days have you been sober? Since
I got arrested, September 7th.
I'm very glad to hear that. And that's in 2023,
2024.
From the Polk County matter.
Yes.
That's a significant amount of time. And it's a struggle. Each and every day. It's not easy for you. It's not, even though it's been a significant amount of time. It's still not easy. I know I have people that I work with in treatment court. You have to choose every day. every day to be sober, and you're making the right choices. And you are the one who made the choice to be in control of your life and not have the substances control you. And that's a positive. I have to look at needing to protect the public, and here it also does include your ex-girlfriend because she is a victim. Of this. And I have to look at the public as a whole because you let yourself get into situation and be under the influence of all of the things that under the influence of a position where you couldn't, your mind couldn't control your body. And so something more serious and devastating could have happened. I do think that probation is appropriate. What I'm going to do is I'm ordering 3 years of probation for both counts. You did sit a significant amount of time in custody. That was needed. That was necessary. I think that was necessary for you to get grounded and probably have the realization that you do not want to go back to prison. You do not want to leave your children again. You do not want to leave your wife. You worked very hard to get back to that relationship. And it's again a struggle with the loss and the significant loss of a child. I'm going to say you have 431 days of jail credit if you are revoked. I'm not doing withheld sentence just from my review of the PSI. You're on a withheld sentence. So I'm going to do an imposed but stayed sentence. 2.5 years. 2.5 years for each count to each other. Okay. And quite honestly, I'm going to let Polk County determine if you are revoked and you do go back to be sentenced. I'm hoping you're not. But if you are, I'm going to let them decide whether or not they think consecutive to my sentence or concurrent to my sentence. But my counts are concurrent. Okay. 2.5 initial confinement, and then extended supervision will be 2 years. Okay, so 2.5 in, and if you're revoked, out, and 2 out if you're revoked. I'm betting that you're not going to be revoked. You're going to use your daughter's memory and where you are now to build your life and your future. While you're on probation, absolute sobriety. No use or possession of any illegal drugs, substances or paraphernalia. No alcohol. No bars, taverns, liquor stores, or establishments that have the primary purpose or the service of alcohol. And Chipotle's, I know some of them serve maybe wine or something like that. That's excluded. So you that's not, they don't primarily serve. Regular testing from your agent. Are you continuing therapy?
I haven't recently. Don't have the insurance. This is what happened.
Okay, and you're not able to get on any type of funded insurance.
No, I make like $800 over that or something.
All right. I'm going to look at all the other recommendations that the Department of Corrections they've asked for anything different. No contact with anyone who is known or suspected to be involved in the use, manufacturing or trafficking of altering substances, illegal substances. I am also going to order the moral recognition therapy, and that'll be working with your agent to determine when that will come into your probation. Any probation that DOC requests. No contact with the victim or residents, except as it relates to. I don't know if there is a restraining order, but no contact unless it relates to facilitating placement for your children, and any modification of the no contact DOC authority authority.
So they may say, they may
talk to her, and
there
maybe
comes a time when
there comes
you
a
can
time
have
when
contact,
you
but
can
I'm
have
leaving that up
contact,
to
but I'm
DOC.
leaving that up to
Okay?
DOC. Okay?
I think that covers everything.
With regards to fines and fees, I think you have significant amounts posted. There shouldn't be any restitution, correct? No restitution. I'm going to order $500 per count. That says inclusive of any fines, fees, surcharges. Oh, sorry. I was thinking misdemeanor.
I was thinking
So it would be $600 per count. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. You must report to probation immediately. I know you're on probation in Polk County, but you still have to, when you're done here, go to probation. I think they may close at 4 o'clock, so I'll give you until noon. I'll say 4 tomorrow to contact probation. You may even be able to just call them because they're going to transfer your probation to Polk County anyway. Because you live, or do you? No, you don't. You live in St. Croix. You live in St. Croix County.
I technically live in Pierce, but I'm on probation in St. Croix.
Okay. So you may be able to just call and they'll transfer to St. Croix County to your probation there. But again, until 4 tomorrow. Let's make sure that I have your address correct. Greenwood Valley Drive.
Yep.
And telephone ends in 8330.
Yep.
Why don't before you even leave the building, at least call probation and need to make an appearance because I want to make sure that I sent you there and that you're not going to miss it. Again, 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. Make sure that the Sheriff's Department has your DNA. If they do, you don't have to give it again. But if they don't have it, you have to get a swab. This matter, I don't think you would be able to.
And that's where this sentencing lands. The judge recognizes the seriousness of the firearm offense and the defendant's past, but also weighs the 431 days already served, his sobriety, employment, and the devastating loss of his daughter. Instead of sending him straight to prison, the court chooses 3 years of probation with strict conditions and a serious consequence if he violates them. Do you think this balance between accountability and rehabilitation was the